In March 2021, the then Minister of Justice, Monica Mæland, commissioned the Norwegian Criminal Law Commission to review the Penal Code's chapter on sexual offences and to consider alternatives to the present rape legislation. After the parliamentary elections in the autumn of 2021, the Commission's mandate was expanded through a reference in the political manifesto of the new government, the Hurdalsplattformen, where the government stated that it will present, quote, present an amendment to the Penal Code to make clear that sex without consent is prohibited and defined as rape. The Norwegian Criminal Law Commission presented its proposed revision of the Penal Code in an official Norwegian report on December 19, 2022. We are happy to welcome Linda Gröning, who since 2019 has been the chair of the Norwegian Criminal Law Commission and who will present the Commission's proposed changes to the rape provision in the Penal Code. Gröning became Juris Doctor in Lund in 2008 and has concentrated her research on issues of criminal responsibility and punishment since. Linda Gröning is a professor at the Faculty of Law in Bergen, where she leads the research group on criminal justice and mental health. Gröning is also employed as a researcher at the Competence Center for Security, Forensic and Prison Psychiatry. Welcome, Linda. The floor is yours.
Thank you so much. First of all, I would like to thank you all for organizing this. It's a truly important topic that you are dealing with. And I will also start with saying that here I will present our proposal from the Criminal Law Commission. This proposal is a start in a political law reform procedure. It is not our personal opinions that we have, so to say, written down in this report, but it's a result of a profound, comprehensive investigation in an area where there are many, many conflicting views on the matter. Our aim is not to, so to say, defend one view, but to take into account all possible considerations, also important legal considerations that are in play, and in this basis propose a reasonable account of what such a rule can look like. We do not claim that this to be the last word in the discussion. And this is therefore, I'm so happy to see that you're so many that are engaged to discuss this. We still not have got the follow-up proposal. And I really think that this should be discussed far broader than what we were able to do in this commission. So, having said that, I just have got some 10-12 minutes to present this. So I will skip over some of my slides. This is just for the sake of order that we were all consensual about all aspects of these proposals. These are the members of the Commission. I would also like to draw your attention that our mandate that we got was not only about what we are discussing here, a consent-based rape legislation, but we have got a very broad mandate to provide an overall review of all provisions in this chapter of the criminal law about sexual offences. We were also asked to balance certain considerations, among others, to safeguard the individual's right to self-determination and other basic requirements of a rule of law design of criminal legislation. We did many suggestions of changes, and what I would like to focus on here, and these must also, I would like to say, be seen in interaction. For instance, we proposed a significant, I would say, emphasis on a better protection for children as being a person under the age of 18, in particular considering the risk of being subjected to sexual abuse and other things. But I would here now go on to this provision. I would like to say that I think that we all share here the conceptual starting point. And we put a lot of time, and we propose and take as a starting point for our report that sexual interaction must be based on voluntariness. We also then took as a starting point that the criminal law must ensure protection against sexual violations. And these are then, of course, defined as precisely violations of self-determination. But at the same time, criminal law should, and is, it should be at least, the last resort in society. I often say to my students that it's a failure for society if we are starting to think that criminal law is the primary tool to solve social problems. Ideally, we should never have these kinds of offenses happening. So criminality and punishment must of course also not affect voluntary sexual acts. We should not suppress individuals' freedom in this area. And this is really the difficult issue. Here I would like to say that I think also it were our observation, I could say, that the problem here is not, and I agree with the myths, and we did, that has been, so to say, proposed here. But the key issue here, that much of what we are discussing here are evidentiary issues. It's a matter that it's so difficult often that many of these offenses is happening in the, so to say, between two or maybe for more people without any witnesses. So when we see there are so many cases that are not punished, it is often because it's so difficult, because there is no evidence. And we cannot, in a rule of law state, switch the evidentiary burden. Nevertheless, the difficult questions that we had to answer was how the individual's right to sexual determination could be understood and protected if we at the same time should ensure adequate protection against sexual violations. And this is the core problem in all democratic states when it comes to criminalization. We put a lot of time to discuss precisely what we have been heard here from the previous speeches. That was like the ideal models of yes means yes, or no means no, or only no means yes, or only yes means yes. We saw here that, and here again, I think that we agree on all conceptual realities. But we had maybe another view than the dissenting opinion of Trine Bamfab for the Danish report about the relation between principles and how we should formulate a rule. We saw that there were some challenging practical realities. Passivity, mostly like a theoretical problem, but still the law must take into account and be, so to say, imagine what kind of situations that occur. Intoxication, not maybe as a matter that we should not, so to say, every, so to say, violation of self-determination should be taken seriously. But it's also a matter of how harsh should we punish certain instances. This, so to say, rule that we are talking about spans over clearly and very, so to say, the kind of crimes that we are often are so agreeing on should be taken really seriously. To more like very difficult, so to say, situations, although they may involve a violation, we could see also that there are circumstances that makes it difficult to say that we should punish it with 10 years of imprisonment. Or 4, or imprisonment at all. So these are like very difficult challenges. Person confusion is a very tricky and very, as I say, we have a case in Norway where it's basically where one is mistaking of a person and that was not a person that you thought you had sex with, that you wanted to have sex. It's a complicated. I will not go into that because of time. we saw that these legal ideals, so to say, about consent, voluntariness, can be implemented in many different rules without different wordings. We saw that it's to a certain extent a contextual matter. Actually, yes can also means no. We, for instance, say a situation where you have a situation of a domestic violence situation with a lot of threats, and seemingly someone that is consenting and saying yes to a sexual act, at the same time showing with bodily expression that this is really difficult, I don't want this. Is it a consent? Is it a yes? He or she said yes. And we could take many such examples, and that makes this field so extremely difficult to deal with. And therefore, we also saw that none of the countries, when really pushed on them, we saw that it seemed like all of countries has not fully cultivated only yes means yes model, in the meaning that there were these tricky situations when one had to, so to say, adjust a little bit on the wording of the rule. So the key question in our view were not about the ideal model, but what kind of actions are really captured by this rule. And the key issue for us were about the lower limit of the crime. The lower limit of the crime, and we have already heard the rule presented. These were our formulation of that rule. It can look like a not fully, I wouldn't call it a no means no model. What we tried to do was really to show the voluntariness, the will component in this rule. For all, it's really a tricky matter to go from concept to rules. For those that has not tried, try to sit down and operationalize a rule by integrating a certain principle in Word and try it out in real complex situations. We are fully aware that this is not a perfect rule, and none is. So the lower limit of crime, which was our emphasis in this, was this. We basically said that it's sufficient for criminal liability that one party expresses that the sexual intercourse is not desired in a way based on the situation it's possible to understand. We recognized that it's needed with a contextual assessment of this. What I said, yes, can also actually mean no. So we emphasized that even small non-verbal signs from the victim could be sufficiently clear expression. For example, if a victim cries in certain situations very quietly, but in other situations, given the circumstances, they may not be enough for blaming someone so severely as punishment with imprisonment is justified. So we argued that this lower limit of crime actually for many practical purposes correspond to the provisions in Denmark, Sweden and Finland, which has chosen another wording in their rules, but not necessarily another lower limit of a crime or another conceptual delimitation. Thank you for your attention.
Thank you so much, Linda, for coming to us and presenting the NOU 2022-21 so that we better understand the background of your reasoning. A consent-based rape legislation is no silver bullet and will neither solve the flaws in the investigation nor the flaws in the prosecution of rape crimes. But what has the actual impact of the recent changes to the law in Sweden, Denmark and Finland been? And how are rape victims in Norway affected by the lack of a consent-based rape legislation? We have gathered a group of respected legal experts here to discuss this issue on the basis of their particular experience. The discussion will be led by Sara E. Sara E is a lawyer at Save the Children in Norway. She has previously been the general manager of Jurk and worked as a lawyer in the law firm Staff. The floor is yours. Please, for all of the panel participants to enter the stage.
Thank you, Patricia. And thank you to all the speakers so far. This has been very interesting, and I do believe that this panel of highly competent women will make it even more interesting from now on. The goal of our conversation is to bring knowledge about the legislation in the different Nordic countries. In Norway, as we've heard already, the law still requires coercion, the use of force or threats of force, or for other reasons, incapability of resisting the act. This differs from the other Nordic countries, who all have a legislation that puts consent in the center. But there are still some differences, though. When we heard from Denmark now, I think it will be illustrated now. But for instance, in Norway, we have gross negligence. In Denmark, you don't.
No.
So that's a difference. There is also some differences when it comes to the use of minimum sentences, which we have in Norway, but not in Denmark. And I understand gross negligence is not enough in Finland either.
Yes.
Yes. I must also say that Samtykkealliansen tried to invite defense attorneys as well. But in their absence, I will try to make some critical remarks and questions as we go. And before we start, I think it might be a good idea, since most of us don't use English in our day-to-day work, to I will try to make a few translations or definitions, also so that we are discussing this on the same terms. Intent and gross negligence will be part of the conversation, as I already said. Super simplified, and you are more than welcome to correct me. Intent means on purpose. You are acting intentionally, while gross negligence means that you have been reckless and your action deviates from what we could expect of a reasonable person in the same situation. You must be to blame, but to a lesser extent than the intentional offenses. Even so, you are far below the ordinary standards when your negligence is qualified as gross. In Norway, rape by gross negligence is criminalized, but not in Denmark and Finland.
But in Sweden.
Yes, and in Sweden as well.
Yes.
Besides guilt, intent, or gross negligence, the principle of legality must be met. This requires that your actions, besides being somewhat intentional, must be criminal in accordance with the law. The provision must be clear enough for people to understand which action it is meant to cover. And we'll come back to that later, because I have, as a representative from Save the Children, I have some questions regarding what maybe young perpetrators understand when it comes to this. And finally, minimum sentences. The court is bound by a minimum sentence. If the perpetrator is found guilty, they must be given a sentence above the minimum. We have this in Norway and I think Sweden.
Yes.
Not Finland. Or yes, but it was 2 years? Yeah.
1 year.
1 year. And we have 3 years in Norway. I don't know about Sweden.
3 years.
3 years, yes. I think that's the most central terms, but I have brought my judicial dictionary from Norwegian to English. It was a bit longer than it looked like on my computer screen. But we will try to help each other out. So if there is a word we're missing, we'll say it in our native language, and we will try to help each other translate. Okay. So first, I would like you to give a quick introduction to yourselves, who you are, and the main characteristics of the legislation in your country. So you can.
Okay, I can start. My name is Kristin. I'm a lawyer. My practice is in Bodø. It's far north, a city located north of the Arctic Circle. I have worked as a lawyer for 28 years, and mostly as a lawyer for the victim, but also as a defense lawyer. And since 2016, I've been a member of the Committee of Lawyers for the Victim in the Norwegian Bar Association. And for the past 3 years, I've been a leader of this committee. And I also was a member of the law committee for a new straffeprosessutvalget. A new proceeding
Yeah.
criminal law in Norway. Yeah. So that's a short story about me. Yeah.
Hi, everyone. Thank you for having me. It's a great honor to be here. So my name is Jessica, and I'm a prosecutor from Finland, the Eastern District in Finland. And I mainly work with crimes against women and children. I graduated in 2019 and worked at Finland's only rape crisis center for about a year before becoming a prosecutor and a junior judge for a while. For Finland, we only got the consent-based rape legislation starting from 2023. So I'm also here very much to learn. We don't really have much case law on the matter. In my district in the eastern part of Finland, we have had about a handful of cases so far. So I'm also very eager to hear what my colleagues have to say about the matter.
And my name is Eva Johnsson. I'm from Sweden. I'm a deputy director of the Public Prosecution Development Center of the Swedish Prosecution Authority. I work in Gothenburg, and I have a national responsibility for sexual legislations questions concerning the Swedish Public Prosecution Authority. I've been a public prosecutor since 2006. I have my current employment since 2021. In my daily work, I gather knowledge of importance for public prosecutors. I issue guidelines, and I'm also involved in Supreme Court issues. But mainly I do reviews of public prosecutors' decisions. So if a public prosecutor declines a preliminary investigation, the defendant can come to us and ask for a review, and we will go through all the evidence and see if there's something we can do. That's what I work with. And in Sweden, we have not chosen the word consent in our law, and that's because that was already taken in another legislation, and the meaning of the consent is in the sexual chapter wasn't exactly the same as we have in those legislation of consent. Therefore, the government chose the term voluntarily participation instead, but the meaning is consent, I can say. We are dealing with it's a just matter. But and we have in our legislation on the matter of passivity, we have a regulation that says when assessing whether participation is voluntary or not, we should particularly consideration is given to whether voluntariness was expressed by word, deed, or in some other way. So we are in, because of this, I'm sorry, can't remember names, but
Linda Gröning.
Yeah, they had struggled with this, but and we had the same discussions in Sweden when we had our legislation 1st of July 2018, but we have we solved the problem we thought by having this legislation and this in our law, and it has worked especially fine, I must say, and since 1st of July 2018. We have it in the Nordic country, we have had it the longest, and it's working real fine. We have done several, as you know, the law is never finished. We always have to screw on it. And we had the latest was in 1st of August 2022, where we criminalized digital rape. So in Sweden, it's also rape if you are behind a web camera and you ask someone to perform a sexual act in front of you. That's also rape in Sweden. That's very concerned with children. That's very important for the children.
Of course.
We have a lot of these cases of internet-based sexual abuse of children. So that's a little bit of me and our legislation.
Thank you. And my name is Gyrithe, and you know from my presentation that I'm assisting state prosecutor in Copenhagen. And before that, I worked as a public prosecutor in the police directory and was the leader of the staff, the prosecutors there. I have in my compartment in the state directory, I have prosecutors who are prosecuting rape cases in the Supreme Court, and we discuss these cases a lot. And then I try to go through all the sentences we get from the Supreme Court, and in this way I sort of follow how they use how we handle the burden of the proof in these cases, and how this consent law is being used in practice. And then I was a member of an advisory board to the Minister of Justice in the period from 2018 to 20, and we were mainly concentrating on how to improve the meeting with the victims of rape, looking into how we could improve the legal counsel for the victims, making we recommended education in trauma handling and trauma knowledge about trauma, and we also looked into the possibilities of using video recording of the victims' statements, which is now a part of the Danish law as well.
Thank you. I would like to hear from those of you who have a consent-based rape legislation already, how it was received by the public, by lawyers and politicians. And for you, Kristin, you can say something about what you miss in the rape provision as it is today in the Norwegian Penal Code. So I would like to ask all of you the same question without, except from you, Kristin.
Do you want to start with me? Or?
Yes, whoever would like to start.
Yes, first I think we all agree that the rape provision as it is today does not protect sexual self-determination. We all agree on that. And this is because, what's already been said, it's not enough to say no, to turn away or cry. You must also be subjected to violence or threatening behavior. Or you must be unable to resist the action due to sleep or intoxication. And as we also heard, it's a fact that many have criticized this Norwegian rape provision. And through my practical everyday life as a lawyer, I experienced that many people in Norway, young as well as old, report unwanted sexual activity to the police, and far too many of these cases are dropped unprosecuted because the current rape provision does not cover what has happened. And I can give you some examples. In my work, I often experience, way too often, that especially young people or people that are vulnerable in other ways are afraid to set boundaries for themselves. They don't want to have sex, but they don't dare to say anything. They are often afraid of the other party's reaction. They feel stupid, they feel childish, they are often immature, and they often have a limited sexual experience. And common to all of them is that they experience a kind of freezing reaction. They get seriously scared, they become kind of paralyzed, and they do not dare to say or do anything or resist. And it is not only young and vulnerable people who describe this freezing reaction. I also have several cases of domestic violence, where grown-up, strong women who knows from experience that if she sets the limits and says no, this will often provoke him becoming angry and violent. And they do not want to have sex, but they don't dare to say anything. They become silent and doesn't resist. And the power or fear for the other party is so enormous that they don't even dare to try, but sometimes they do, and therefore they know. And this kind of freezing reaction and submission based on fear is a big problem in Norway, a huge problem. And this is important. Cases like this will not be covered by the rape provision based on a no is no model. And these cases will not be covered by the conviction unable to oppose the act in the proposal of a new section 294C. And from the practical life, we know that the level is very high for conviction after that legislation. So I'm very concerned about these victims. And it's a fact that these cases of unwanted sex could have the same consequences for these victims as for others. So for this reason, and among others, no model will not be sufficient, and I will say that Norway must change the rape provision to a only yes means yes model.
For Finland, how it got started, how the conversation got started, is, to my understanding, very similar to Norway, where the Grevio committee that supervises the Istanbul Convention gave Finland these notifications about the current or the former rape legislation, and that sparked the conversation. It was already discussed about 10 years ago whether to add this consent-based model into the sexual crimes chapter, but back then it was deemed that there would be too much focus on the victim and their behavior as opposed to the actual the perpetrator's behavior. So then that was scrapped with very little discussion. There was also politicians in the beginning 10 years ago and even recently, before the legislation was passed, felt that this consent-based model is not appropriate for a normal life. Which is a very interesting statement, but this was kind of a fear that it would not work well with normal life situations. Then finally, in 2018, there was a citizens' initiative, which means that a citizen starts an initiative and needs to get 50,000 votes or signatures for the matter to be discussed in Parliament. And that's how this got started in Finland. So based on this and based on the discussion, I would say that there was a lot of support from citizens. It was mostly politicians who were unaware or afraid of how this could be implemented into law.
But how about the legal environment? What was the reception there?
Very good for the most part. Of course, there was a little bit concern about how to model the wording, but we were fortunate in the way that Sweden had already done it, and we always look to Sweden in almost everything. So
not in NATO cases.
Yes. So it was then looked towards Sweden a lot, and now when you read the government's proposal for the legislation, it refers a lot to the Swedish legislation.
But you were surprised when I told you about the gross negligence.
Yes.
And that differs from Sweden.
That's very different, yes, and it's discussed in the government's proposal in some way, but the problem was also that the gross negligence is a little bit different in Sweden and in Finland, how it's determined in criminal law, which is also a reason why it was not really ever considered, and no one really brought it to the table. Should we talk about this? There's a mention of it, but then it was scrapped quite quickly.
Thank you. Please, Eva.
I can reconcile that in Sweden we have the same debate before this legislation was in place in 2018. And I remember, I thought about it on the first speaker today. We had the same discussions. Oh, now I have to video. Can you say yes to the video so I know I have to, so I can have sex with you? All those jokes and all those we had in Sweden before. But since the legislation was in place in 2008, this is out of tune. We don't have that anymore because this legislation has fallen into places, and the legal system and in the community in all, it is accepted as a rule that is that is okay. We have had several cases that has been the Supreme Court of Sweden has tested this law in several cases, and they have accepted the law as possible to use. And all those difficulties, there are always difficulties in law. You can never have a legislation that counter every bit or part of the social life. That's impossible. But we have had during this travel with this legislation, it has fallen out very good. And we had the Swedish, I have to read from my fusklapp, the Swedish National Council for Crime Prevention made you talked about them earlier. Yeah. They looked out and saw if this legislation had fallen out well or not. And in their report about, they could see that the number of prosecution and convictions has increased 75% according to since the 1st of July 2018. So it means a lot of more conviction and a lot of more indictments. And the prosecutors in Sweden think the law works perfectly well. We have the same issues about the evidence evaluation, and we have the same situation as you referred to earlier. There's often two people in a room, so that's not changed. But we have a change in what you call förklaringsbörda. And that is when we have a preliminary investigation and we investigate these cases, we are more focused on the perpetrator. And we ask him, I say him because as in Sweden it's not always, but mainly a man. How did you know that she wanted to have sex with you? That's the question the perpetrator have to answer. How did you ensure that she wanted to have sex with you? And the consent have to be during all of the sexual act. We had a recent verdict from the Supreme Court where she had consented. She said yes from the beginning, but then he did something that she didn't want to. And the Supreme Court said, that's rape, because she hadn't consented to this last part. And this verdict was just 2 weeks ago. So the consent had to be during the whole sexual act. So have you said yes to one thing, doesn't mean you have to accept all the sexual acts the perpetrator wants to do. So mainly I think but we are still, as you know, we have to work with the legislation and so on and forth, because there's always things to do. And I'm just now reading a state report with a proposal for a new change regarding the victims between 15 and 17, who's more vulnerable than adults. And they're trying to fill in some of the gaps in the legislation. But the discussion was the same, but the discussion has ended because the legislation has worked. And we have gross negligence, which is, I understand, is a worry in Norway. Yes, but we have that, and the Supreme Court has tested that we have severe convictions from the Supreme Court, and it works with a consent law, I must say. It doesn't have to be a problem.
But aren't you worried when there are young perpetrators? Because I think about what Linda Gröning said about there are jokes about consent and the contracts and everything, but it can be a bit simple also when you say that for children, you can say the other party has to be a game. It's as simple as that, but it's not always as simple as that to know if the other party is game, at least when there's young perpetrators, alcohol in the picture, and it's...
But you have to
and porn is your main source of knowledge about sex.
We see that in Sweden too, and I see also the things that you said about how the victims, the young girls they feel they can't say no because they're afraid. We see that too, but you have to trust the system, and those cases never go to court. If you have a case where we can, under the system, during the preliminary investigation, we can see that we have a young boy, 16, who hasn't understood, and he hasn't been gross neglected either, then there will be no indictment because the system works. I mean, in Sweden, you show the figures for Denmark, and it's the same in Sweden. We have about 25 or 30% that goes to, there will be an indictment and a conviction. So you understand that 75% of the cases never go to court. So the system works because the evidence problem is there. And the that's an evidence problem. What did he understood? Has he been grossly neglected?
And you have the same rule as well, because we have, when it comes to what's it called, inducted alcohol influence.
Yes, we have the same.
Yeah. So then you say you would have understood it if you were sober.
Yeah, if you could say that if you had understood it when you were sober, then you could have also had, and you would have done it anyway, then it's grossly neglected, and then you should be convicted. And the Supreme Court of Sweden had a verdict for, I can't remember exactly the year, but they said if you are unsure, it's very simple, just ask. Said the Supreme Court. And that's also for young people. And I understand this, it's very severe for the young people who are they're insecure about themselves and the sexual act and all and their experience. But we also have legislation of minor rape. So it maybe not be rape, it could be a minor rape in those cases. That's not so severe. So you can have those. We have some, I don't know the word in English, but you know, rubber bands in the legislation we can use. We also have a paragraph about if you have if there are young people and both are young. We say the one is 16 and the other one is 15 or 14. It's minor. And they're very close and they have a relationship, then that's not a crime if they both voluntarily have sex. Because in Sweden you can't have sex with a child underneath 15. It's always rape. But we have also here some rubber band for just these young situations.
But then you use another section in the penal code?
Yes. It's another. Okay. It's rape against children if you are under 15.
No, but I was talking about when there are two, if a minor rape.
Minor rape is another.
Okay. Yeah. Thank you. And Denmark, I know we know know most about the Danish legislation now, but I know that you were speaking at the Nordisk juristmøte. Yeah. And you had this debate with the Swedish lawyer. Yeah. Can you tell us a little bit about differences in how you...
I think actually that debate, we've seen that in Denmark as well. These worries from the defense lawyers that there is less justice to the perpetrators now. And it's quite funny because justice is not, in my opinion, it is not a sort of fixed amount so that if I give you 3, there'll only be 2 for me. So the fact that we are giving more justice to the victims doesn't mean that there's less to the perpetrators. And as you said, the system works. If there's reasonable doubt, they will be acquitted. So I think that's what we've seen, and I think these worries have sort of died away now.
Thank you. We also discussed whether the new consent-based rape legislation might contribute to more attention to the offended. And I hear you say it doesn't, because now you have more attention to what did you do to make sure that she consented. But at the same time, I might be the only one who wonders about this, but isn't it possible that how did the offended behave that might have been interpreted as a consent? Won't that leave us in the same position? If you understand what I mean, if you're going to court, what could you possibly have done who the perpetrator might think was a consent? And then you're back at the same starting point, aren't you, how did you act? Or is this something I constructed as a problem?
No, it's always a problem when you have people involved. Because people react differently. And of course, if you have a preliminary investigation and you have a court, you have to, of course, have an interview even with the victim. And you have to have respectfully ask in question about what have been done before? Have they met before? What was discussed? How she? That's the part of the investigation, because we have the burden of proof as prosecutors, and we have to show convince the court that this was intent rape. And if you are going to do that, you have to ask questions even to the victim about how she was reacting and what was but you have to do it with respect. And then, but we don't ask the victim if she had high heels and short. We have that in Sweden too, high heels and short. And if you are drunk, you have to. It's your own fault. We don't do that, but we still have to ask questions about what happened before, because otherwise we can't waive the evidence. We can't waive these stories. We have two stories, one from the victim and one from the perpetrator. We have to weigh them against the evidence, and we have to.
But I think we are now asking the perpetrator more than we did before.
Yes.
What made you think that she consented? Why did you think she wanted it? And these questions we didn't ask in the same way earlier.
And earlier it was he could always say no, she wanted to, and that was that. We didn't ask any more,
no.
And now we do.
Yeah.
So I think that's the change. But
Did she say anything?
No.
Did she move in a special way? Did you have this eye contact
Yes.
with her to make sure that you agreed this was what you were going to do together?
Yeah.
And Kristin, in your experience in Norway, who does not have a consent-based rape legislation, how is your experience when it comes to the offended, whether her actions or behavior is being scrutinized as it is today?
Of course, it's very important to ask both parties, both the police and the judges. The law system needs to know both stories from the beginning, during the sexual act, and afterwards. So I think, regardless of which the wording in the law, this is important questions.
But is it your experience in Norway today that, for instance, how you dressed or how you act, is it a subject, or is it a myth?
Yes, sometimes it is a subject, and sometimes it might be a subject. But we are well aware of that, the victim lawyers and also the judges. So you ought to be, if you need to ask that question, there needs to be a good reason for it. If the change of the law will change that, I'm not sure, because it could be a question to ask.
Yeah. I can take an example. I had a girl who told me, it was during my time as a public prosecutor, I had a girl who said she had been raped, and she had a pair of jeans on her, and I couldn't understand, how can you be raped if you have it was vaginal, I don't know, do you know?
Vaginal intercourse?
Yes, thank you. And how is that possible? I thought she had her jeans on. But then we had taken these jeans, and I saw a photograph of them, and she had a giant hole in the jeans, just here. And we found DNA traces from him in this hole, and he was convicted at rape. So the clothing can matter.
Yeah. Yes, of course.
And both ways.
And Kristin, I would like to ask you in a Norwegian perspective. Section 297 in the Norwegian Penal Code criminalizes sexual act without consent, sexual act, not rape. The wording is, a penalty of a fine or imprisonment for a term not exceeding 1 year shall be applied to any person who performs a sexual act with a person who has not consented thereto. There is a legal requirement of intent in this provision, but still, in your experience, how has the objections we hear about consent-based legislation been met in the practice after this one?
Those who do not want an only yes means yes model often argue that this section 297 applies to less serious crime with a penalty up to only 1 year. But the rape provision, we have much higher penalty, up to 10 years. And the higher the penalty is, the stricter the requirement of the clarity in the law will be. So therefore, the Section 297 is not a problem regarding the principle of legality, but in the rape provision it could be, they say. And I do believe that these arguments tåkelegg, I don't know the English, obscure the debate, because we already have several other provisions in the sexual chapter of Criminal Code that set consent as a condition. Not only the 297, but also 298, 311, and in the chapter regarding violence, there are many provisions which requires consent from the victim, with higher penalty than in 297. For example, the provision of mercy killing, the Norwegian word is barmhjertighetsdrap. Murder has a minimum sentence of 8 years in Norway, but if the person who is killed has consented, then the sentence can be reduced.
Yeah.
So that's a paradox, and how to figure out about that consent when the person is dead, but that's another discussion. But so when did this word consent become so difficult?
It's because it's about sex.
Yeah, but it's a way of avspore the debate, simply. It's not a problem at all.
I think it's because it's about sex. It gets so close to you. It gets so close to everyone, and because it's always when you have to discuss sexual acts, then everybody gets on the toe and tiptoes. And it's because, as you say, we can discuss consent about murder, but we can't do it when it comes to sex.
But don't you think it's different also because sex is something that most people want? And in most, or maybe I can try to say that differently, in most situations or whatever, but very few want to be killed or beaten or robbed, and because some of the difficulties, which of course we should all try to make as less uncomfortable for the victim, but at the same time it is different because when you say, will you ask someone, did you want to get robbed? Of course you don't, but it's not the same.
And basically it is legal. You can have a sex.
Yes, it's thank you. That's probably better than mine.
But I don't know how it is in Norway. But in Sweden you can consent to violence.
Yes,
I mean
fight club.
But every boxing area or a Swedish hockey game, I've seen. There's a lot of violence, so you can consent to violence, also. But I think it's something about sex that is so close to your heart that it's difficult for people to discuss, and then it's very sensitive in another way than other things. I think that.
I would like to follow up on something you said in your introduction as well, when you talked about digital rape.
Yes.
Because when I spoke to you on the phone, you said something about if the parties haven't met physically before, it takes more to the consent of the. Maybe you can try to explain it.
That was when we discussed the gross negligent cases. That like in all cases, you have to try the evidence and you have to see what has been. And the Supreme Court of Sweden has said when they tried our legislation that if you have one victim and one perpetrator, and they have not met before, they have never had any contact at all, and we have the first case was that they had only spoken by, young people today, they live their lives in the digital world more than in the real world sometimes, and they had contact on the digital world, and she had said, I don't want to have sex, you can sleep over, but I don't want to have sex, like the case you referred to. And this was the first time they had sleepovers, and he had sex with her. And she had just put her pajamas on. She has a pajamas t-shirt and her trousers, and he had sex with her anyway. And then the court said, no, that's not okay, because they hadn't had any discussions about that earlier. She had been clear about she didn't want to have sex the first time. But of course it's different. I mean, if you have a long relationship, you have been partners for years, then, I mean, in Sweden it's not okay to have sex with someone who's sleeping. That you can't participate voluntarily if you're asleep. That's, everybody understands that. But if you have been partners for years, you can evolve some where it could involve behaviors where it's okay.
Like passivity cases.
Yes, like passivity cases.
Yeah.
Like it's okay, for example, to start having sex. I can woke you up by kissing and caressing, and then it leads to sex. That's okay because we have been partners for years, and I okay with that. And in that is how I meant that this has you have to take this in consideration when you see on the act. So who you are investigating? How does the relationship between the partners? I think it's the same in Denmark.
Exactly.
Yeah. But when I talked about digital rape, it's when you have a person. We have had cases in Sweden where a man have grooming on a young girl, and he has made her do sexual acts on herself, and he's looking at a web camera, or she films it and then sends to him. And earlier this wasn't considered rape. It was another paragraph in the legislation. But since 1st of August 22, this is also rape, because the girl isn't involved voluntarily in this. She has been groomed to do this. So what we have in Sweden is that we can have convictions of rape, even if the parts, the victim and the perpetrator, doesn't have to be in the same room. They can be in different places. It's very complicated. I know. I hope you understand. It's very hard for me to explain in English.
No, I thought you explained it quite very well. Yes, I would like a round again. Maybe it's a short answer. Maybe it's more complicated. But minimum sentences, good or bad? You can start, Kristin.
I do believe that minimum sentences is bad. Because I'm quite sure that we get a lot more convictions with the minimum sentence rule. It's 3 years, but in normal cases it is 4 years. And I have seen several examples that the judges convict or doesn't convict, especially young people. Because they think it's too much. So that's the main reason why I think that we should trust the law system to find out, because rape is quite much different situations. And we must trust the law system to find out a penalty in that case, regardless of this minimal sentence. So I think that is the best, but I've doubted myself to that meaning. But I do think that is the way to go.
I feel in Finland I don't have a strong opinion on the matter. Rape is carries a minimum sentence of 1 year imprisonment, which if a person was convicted of 1 year, it would be a suspended prison sentence, most likely, unless there's lots of other cases that they're also convicted of. But if they're a first-time offender, it would be a suspended sentence. So I feel like that is reasonable, and it does send a message that rape is something that can only be punishable by a prison sentence, not, for instance, a fine. So it does send a message in that regard, and I do have a fear that if there was no minimum sentence, there might be some very lenient judges who might find that actually this is a young boy and he's comes from a good family, he's in school, maybe a fine would be reasonable in this regard. so that's why I'm a little bit hesitant about not having any minimum sentences, but I agree that if it is 3 years in Norway, it does sound kind of high and might result in the judge not convicting the person at all.
In Sweden, we now have 3 years as minimum imprisonment for rape, and we had a lot of worries because it was recently, it was also in 1st of August 22. Before that, we had 2 years in imprisonment. And the government thinks the judges don't do the homework, and they always go for the minimum, no matter less how severe the case is. There's always the minimum. If they take in from the tiptoes, really, they take 2 years and 2 months. So I can understand why you want to send the message, as you say, that this is rape is the most exception for murder, the most severe crime because it goes so inside the victim. There's so much damage to the victim, much more than if you have been beaten up. So I can understand that, but we have had the worry that, just as you say, Christine, that the judges they think 3 years is a must, but is too much. But we haven't seen that really. So but we are not have it so many years, so we follow the question.
But are your judges, are they laymen as well, or are they just the legal judges?
Both.
Both, yeah.
It's one in the first court. There's one legal judge and 3 laymen. And in the high court, there's 3 legal and 2 laymen. And the Supreme Court is just legal.
Yeah. Is it similar in Finland?
Quite similar. It's in the first instance, it's 1 judge and then 2 layman judges, though we are moving away from that a little bit towards 3 judges already in the first instance. And then from the second instance onwards, it's only legal judges.
You can answer that as well if you'd like, Gyrithe.
Yeah,
and also
we don't have minimum sentences in Denmark, but anyway, as I said in my presentation, the judges do follow the guidelines made by the consent law. But I think we have to recognize that rape is many things. The severeness is not the same in the whole spectrum of. I think we have to acknowledge that. I know it's traumatizing and it's a very severe crime, but it is not. Every case is not equally grave.
I agree. I think the same.
It's because that's it's also an interesting debate now when we have 3 minutes left or something. But it's easy sometimes to look, because as you said, it's very damaging for the person, and just look at the consequential damage of it. But we also, as lawyers, we know we also have to look at the culpability, the degree of guilt.
Yeah.
And that can be very different in different cases.
Exactly.
Which also brings me back to the young perpetrators.
Yeah,
and
exactly.
I would really like you to, we could probably discuss this for days, but I would be, I'm doing this in my work time in Save the Children. I would be a very bad employee if I didn't raise the issue of security under law for young perpetrators, which is an issue I am deeply engaged in. And I mean, gross negligence, we've discussed it a bit. Only yes means yes. Porn as the primary source of sex education. Like Linda Gröning said, you have to understand it's, back to culpability, to understand that what you're doing is violating what's in the provision in the penal code. It's not always that easy. Do you have any concerns like this when you are prosecuting cases, or you are an attorney in these cases, when you see some of the young perpetrators, or is this not a problem?
I actually think with the consent-based model, it's a lot more understandable for everyone. The previous legislation was very similar to what Norway has now, where it's either violence or the person is in a state where they cannot consent, passed out, sleeping, etc. And in those cases, it was always interesting to you had to kind of, or the courts found a way to find something to be violence, like moving a hand or a slight nudge, something that might not necessarily be what was intended as violence, but because the courts already started leaning towards the consent-based model. So now I feel like it is more clear to everyone involved that only yes means yes. So I think it's actually a better step for potential perpetrators as well.
That's very interesting, because the principle of clarity part of the principle of legality has been like one of the main objections to consent-based rape legislation in Norway. And what you describe now is that instead of interpreting the law utvidende, as we say in Norwegian, which is very problematic in criminal cases, then what you are saying now is that when you have, like, the legal frames are more tydliga,
more clear.
More clear,
yeah.
yes.
Yeah.
That's interesting.
Yep.
Yeah, and I agree. I think also this legislation is more easy to adapt, and it's more easy for the young to understand. But I also think we have to have a discussion in all our communities about, but that's something for other authorities than the legal system. We can't, as you said earlier, fix everything. I think we have in the society to have a discussion about how we are against each other, how young people should sexual understanding, education. You have to have education. This is a question for the education. And I know, but when we changed system, there was a huge amount of education programs for the schools and for the public, for everyone to understand what this new legislation was about. So I think most young people always could understand it. If they can't, you can always look up in YouTube. There's a movie called Consent, Don't Make Them Drink Tea.
Yeah.
Yes.
And have you seen that? If you see that, you can always understand what it is. And all young people understand that. If she's asleep, don't pour the tea in her.
Yeah.
So I think you shouldn't underestimate the young people either. But I understand the question, because it's also, if you have a boy that has been accused of rape, I have seen some cases too, and there's nothing to it. There was no rape. And he had to leave school, he had to move to a different town. So, of course, that's a problem on this side too. But
Yes, and one thing is to understand the tea video when you are sober. But when young people are drunk, it's maybe not that easy.
I can see a lot of adults who doesn't understand when they're drunk either.
Yeah, but then, that's my point exactly.
I think that's why people drink sometimes.
Do you have any comments on the young people?
No, I agree completely. Yeah.
But what you said something about 40% of 16 to 20-year-olds didn't understand, or were not sure that they would understand.
Yeah. That's how they answered the question. Now, we don't know how the question was posed. Trina and I talked about it. If you ask somebody, are you insecure about this? Most people would say, yeah, well, yes, I'm a bit insecure about this. But anyway, 40% of the young people from 16 to 20 said that they were insecure about how a non-verbal consent was given.
Yeah.
And but they were young people who hadn't had any sexual experience themselves. Their knowledge about sex came probably from porn or whatever. And I think that's a point as well. When you get the experience, you find out what consent is. But of course, you shouldn't go ahead and rape somebody in the learning. But I think that's a very important issue to communicate, educate the young people.
Yeah. Would you like to say?
No. The time is changing, and we are making this law for our children and the upcoming generations, and with Andrew Tate as a role model, and I think my children looks very different on the sexual subjects, a whole lot of different than we did. So we need wording in the law that's it's simple and easy to understand.
Yeah.
I would like. I didn't cite the whole quote from the district attorney in Møre og Romsdal, but you have read it. Because I told you that several of the Norwegian district attorneys gave their response to the recommendation of the Criminal Code Council. So you know why I'm saying this now, is that you know some of the main objections from your Norwegian colleagues about this. And just to say that the Norwegian district attorneys they didn't agree all over, but I cited one of their responses to you. So at the end, I would like you three to give us, with that in the back of your head, the main arguments. How can we convince the Norwegian legal, other legal, to make their concerns about the principle of legality and legal clarity? That, in your experience, I understand it's not a big problem. And for you, at the end, I would like you to say what the wording in the new penal code should look like. So please, Gyrithe.
Well, they can use our experiences and look into our practice. As I would say, the Danish judges didn't like the consent law either, but they have learned how to use it. And when you look into it, it's not that difficult. Judges are used to making this weighing of the different explanations from parties in court cases. So they're trained in this. And rape cases have always been difficult. Yeah. We also, earlier, when we had the old law, we also had very difficult cases where you had this two sayings against each other, he said, she said. So this is not new, and I think you can find it out.
I can understand the concern, absolutely, but as you say, there were a concern in our country too, but the judges don't think it's that difficult today, because just as you say, they're used to convictions. They are used to hear these witnesses and all this, and they were not easy cases before. No. And I have public prosecutor colleagues who was very concerned, and I still have colleagues who are concerned, but mostly this is colleagues who don't work with these cases, because we who work with them, we know it because I have colleagues who work with narcotics, for example, and they have much, heavy evidence. There's DNA and there's narcotics and there's much technical. And what do I have? I have a story. And she had told a friend or something. I had to work these cases on a different level. And therefore we, in my department, are now working on a guideline for public prosecutors, for methods for working with these cases, because you have to work with them.
I'd like to see those.
All cases have its difference.
I completely agree with my colleagues. I think ultimately the legal space in Finland, because it was already so consent-based, or it was interpreted in a consent-based way beforehand, it really hasn't changed that much. It's only been clarified. But I find from my work that the big problem is the evidence, or the lack of the evidence, not so much if something is rape or not. So I don't see how this changes the situation for the worst. It just clarifies it a little bit, and we still have the exact same thresholds as prosecutors to show our case, and difficulties getting the evidence in the first place.
It's a mindset, I think.
And the wording in the law. If we are to choose between those two suggestions from Straffelovrådet, it's of course the alternative proposal from them, have sexual intercourse with someone who do not express in word or deed. I mean, that is a problem against the principle of legality. So the first proposal, I don't think could be the way to go. But the second one, I don't really fancy that either. I do believe that the Danish model is the best. Oversatt, translated to Norwegian, den som har seksuell omgang med en person som ikke har gitt sitt samtykke. That should be the wording in the Norwegian law. Simply as that.
It's very clear.
Yes, and I think with that being the final word, thank you all of you. This was very, very interesting, and I think you all agree on that. Thank you.
Thank you.